So in part three, we're going to take a look at affirmative action. We're going to look at Congress's role in a number of laws passed related to civil rights. And then I want you to take a look at Letter from a Birmingham Jail, which is the last of the required documents for the AP exam. So affirmative action is the term for a collection of policies, practices, programs used by public institutions. So that would be like public colleges and universities, government, like the federal government, state government, local government. And these are policies that are used to correct discrimination of the past several decades in the history of the United States. So trying to make it so groups that historically did not have access to government jobs, did not have historic access to admission to colleges and universities, that these groups are given a chance to participate, have a role in, gain access to these different institutions. And I like this image because I think it does a pretty good job of explaining what affirmative action is. That we have the woman standing on a box to put her to the same height as the man. So thinking of, it says like here, you must be this tall to enter college. So thinking of the advantages that white men have had historically in the United States, that they have had access to everything, access to government jobs, access to elite colleges and universities. And this is affirmative action is trying to make it so that the like groups that haven't had the same access, so like women, people of color, that they also are given an equal chance to receive admission to a university, to be considered for a government job. Now, we're going to look at a couple of cases that are not required for the AP exam, but you do need to know what affirmative action is. You don't need to know the names of the cases. And these cases are going to involve universities and admission to universities. There's a case right now in appellate courts. The U.S. Circuit courts just heard a case involving whether or not there is discrimination in Harvard's admission policies, specifically related to Asian Americans. And there's a video that I put on the YouTube playlist. It's a video from Vox called What We Get Wrong About Affirmative Action. So take a look at that. I think it does a pretty good job of explaining how affirmative action works, as well as connecting it to a case that may soon go before the Supreme Court. So again, you do not need to know these cases by name, but you do need to know what affirmative action is. So in the 1970s, there was a case that went before the Supreme Court, Regents of the University of California v. Bakke. It was a man who was denied access to the medical school at one of the University of California branch campuses. He claimed that he was denied admission because he was white. The Supreme Court said that affirmative action and policies of affirmative action meet strict scrutiny standards. So having policies that take into consideration someone's race, their national origin, or their gender, that is something that public institutions can use. And it has a compelling governmental purpose. So the compelling purpose is trying to make sure that all Americans have equal opportunity to receive admissions to universities or the opportunity to receive government jobs or government contracts. But they said, however, in this case, the University of California's policy of setting aside a quota, so saying like, oh, okay, we're going to admit like 5 Black students, 3 Latino students, and 6 women, that setting an actual quota, that's a violation of the Equal Protection Clause. But the Supreme Court said that yes, race may be used as a factor, one factor, when deciding admissions to a university. And these standards also apply to private universities that receive federal funding. So institutions like Harvard, for example, it is a private college, but they do receive contracts, research contracts. They receive money for Pell Grants, financial aid, so federal money. So any institution that receives federal money, be it contracts, research grants, that they also have to follow these standards. Again, this case came up in 2003. It was looking at the University of Michigan Law School. They were applying points that you were given a certain number of points, like you had to get like 50 points to get to be admitted. I'm just making up 50, and it was like, oh, well, you got like 10 points for graduating summa cum laude. You got 3 points for being an athlete, and then it was something like 15 points for being black, or 16 points for being a woman. That system, like that point system, that was deemed to be unconstitutional. It does not meet narrowly tailored standard for strict scrutiny. So go back to the Civil Rights Law Explained handout. Again, underrepresented minorities can be a factor, but it can't be the deciding factor into whether or not you gain access to a college or university. And then the last time the Supreme Court took a look at this was in 2016, the case Fisher v. University of Texas. That University of Texas has an admission policy that is narrowly tailored, thus constitutional. So their policy was that the top 10% of your class at any Texas public high school, that you would receive automatic admission to UT Austin. So it doesn't matter if you were in the poorest of poor schools, if you were in the richest of rich schools, as long as you were in the top 10% of your class, you received automatic admissions to the University of Texas. And that was, again, challenged because it was saying that that was unfairly discriminating. And a lot of these cases, the issue is unfairly discriminating against white men who have had historic access to these institutions. In this case, in Fisher, and I believe in Grutter as well, I think they were both women. But again, they were white people arguing that they weren't being treated fairly because of affirmative action. But the Supreme Court, time and time again, since 1978, has upheld that affirmative action is an important part of achieving the goals of the 14th Amendment and maintaining civil rights in the United States. So let's take a look at laws relating to civil rights. Of course, the voting laws, the 15th Amendment, the 19th Amendment, the 26th Amendment. So the 15th Amendment giving rights, it's universal male suffrage, so the right to vote for all men. The 19th Amendment, the right to vote for women. And then the 26th Amendment, the right to vote for 18-year-olds. You could also take a look at the 23rd Amendment, which gives the right to vote to the District of Columbia, would also be another example of civil rights legislation. The 24th Amendment, that is the amendment that eliminates poll taxes or any other obstacle related to taxes and voting. Like you can't have to pay. Essentially, you can't. It's unconstitutional to pay a fee to vote. The Civil Rights Act of 1964, that prohibits discrimination based on race, color, religion, sex, national origin. It applies to employers, public accommodation, schools, and any institution that receives federal funds. And it was later amended. So things like Title IX, which if you've heard about in the context of education and like athletics, that no person in the United States on the basis of sex shall be excluded from participation in or be denied the benefits of or be subjected to discrimination under any education program or activity receiving federal financial assistance. So the Civil Rights Act was then followed by the Voting Rights Act, which prohibits racial discrimination in voting. And it also then removed things like any kind of voter qualification or prerequisite. So that would be the like those literacy tests, the quizzes that you were forced to take, like naming absurd things like, oh, the state Supreme Court justices, or being able to recite your state's constitution. So those literacy tests, those things were then eliminated by the Voting Rights Act. So together with the 24th Amendment, that removed obstacles towards citizens and voting. And then the other part of that is that areas with a history of discrimination are subject to federal approval if they were to change any voting laws. It's called Section 5 of the Voting Rights Act. However, that was then ruled unconstitutional in Shelby County v. Holder in 2013, arguing that Section 5 is outdated. So I don't think, again, you're going to need to know a lot of these by name necessarily on the new on whatever new AP exam that you're going to be taking in a few weeks. I don't know. But do know, like Civil Rights Act, Voting Rights Act, that there are a number of laws that were passed to also achieve this goal towards making sure that as many Americans as possible get to participate in our government, have access to the same rights, have access to the same feelings of security and liberty in the United States. The Equal Rights Amendment also kind of falls into this category. So it was introduced in 1921, revived in 1979, that equality of rights under the law should not be denied or abridged by the United States or by any state on account of sex. We know that Virginia was the 38th state to ratify the ERA, and kind of like, so what now? So they ratified it this January, so in January 2020. Here's an article that I linked to if you want to read about it, that essentially the understanding is that the House of Representatives and the Senate would have to pass a law saying that they're extending the deadline for the Equal Rights Amendment. And the Equal Rights Amendment from 1979 had an expiration date that so many states had to ratify it by the deadline, and that deadline was in the early 1980s, and Virginia ratified it like almost 40 years later. And what does that then mean? There's a lot of question about that, a lot of questions about that, how that actually happened, how will that work? Is it actually now going to be the 28th Amendment to our Constitution? Constitutional law experts are kind of weighing in on what will happen, and the House of Representatives and the Senate, of course, are going to have to pass a law extending that deadline. The other part of this, and this question and theme of who's most responsible for who's most responsible for the expansion of civil rights in the United States? Is it social movements? Is it Congress? Is it the Supreme Court? So take a look at Letter from a Birmingham Jail that I posted in modules. It is a required document, and I'd like you to answer the questions that go with it. Again, I don't know how this is going to work on the redesigned exam that you're going to be taking in May, the 45-minute FRQ. I don't know if that's going to include an argument essay, but still be familiar with the document. So this is the civil rights argument essay that could possibly appear if we were taking the exam as we expected it to. So which of the following is most responsible for the expansion of civil rights and civil liberties, social movements, the Supreme Court, or the legislative branch? Use Letter from a Birmingham Jail, the required court cases, and other specific legislation to support your position. So if you want to take a minute to outline this, think about how you would go about answering it. I think that definitely would help you. It's definitely not going to harm you, and it would probably help you to better understand these issues, because civil rights, civil liberties, that is one of the units that is required for this condensed exam. So if you understand these big concept ideas, that's probably going to be most helpful for you in writing the free response question. So if you go to Canvas and you pull up Letter from a Birmingham Jail, so that is right there. This is the final document that you need to be familiar with for the AP exam. So Letter from a Birmingham Jail, this is the handout that College Board produced. So if you go through, take a look, there are questions in the margin to kind of help you think about the purpose of this document. And then these questions at the end, I would like you to read and see if you can answer them. So what was the process for achieving gains in civil rights that Dr. King described? What challenges might a social movement using this process encounter? How might a social movement using this process overcome this challenge? And what is one implication of the process outlined in Dr. King's argument? How might this process affect policymaking, other social movements, and another political example, institution, process, policy, or behavior discussed in the course so far? So Dr. King is essentially, I just realized in making these videos that I use the word essentially a lot. But Dr. King is arguing that civil rights, protests, demonstrations, boycotts, they make people feel uncomfortable. And when people feel uncomfortable, they then put pressure on policymakers to create a change. So the protests themselves might not reach the end goal, but if somebody in the protests combined with the people who aren't protesting and kind of getting this feeling that things are tense, things are uncomfortable, there needs to be some kind of change. That's ultimately what leads to a change in policymaking, because members of Congress, the president, they're going to feel really uncomfortable when there's a lot of pressure on them to do something. Pressure that is coming from those participating in the social movements, but then also those who are not participating. Because people who are not participating, if they start to feel that something is wrong, they start to get kind of an icky feeling, then they're going to want something to change. And Dr. King writes about the purpose of his demonstrations. So take a look through, read these, and then answer the few questions that go with them, and then ask me if you don't understand something.